Have you heard about a public charge? You can't be a public charge or be in danger of becoming a public charge if you want to get a green card in the United States. My name is Andre Major. I'm an immigration attorney and an immigrant. And in today's episode, I'm going to discuss the proposed changes for the public charge under the Biden administration. We're going to compare that to what the Trump administration wanted to do. Before I begin, please click the subscribe below button and hit the notification bell so you can get all our latest updates. Also, feel free to leave a comment below about your thoughts about today's appointment and check out our other videos. Let's get started. The Biden administration has proposed changes to the public charge ground for inadmissibility. It's one of the ways that USCIS has to say, hey, you're not eligible for a green card. Now, overturning the Trump administration's public charge rule, which is what this change would do. Now, the Trump administration's public charge rule was criticized by many people, myself included, as a wealth test. And it dramatically shifted the long-standing definition of a public charge. And by long-standing, I mean, for about 100 years or so, since 1882, when the public charge rule was introduced. So there was a long practice of application for the public charge. And the Trump administration decided they were going to define it differently. So, what are the proposed rules for the public charge? Proposed rule number 1, defining the term likely at any time to become a public charge. Department of Homeland Security, DHS, has proposed to define this as likely at any time to become primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or long-term institutionalization at government expense. So, primarily dependent is a key term. Government assistance, and by government assistance we mean public cash or institutionalization, paid for by the government. Proposed rule number 2, adopting the same list of public benefits under the 1999 Interim field guidance. The term public benefits refers to public assistance for income maintenance and long-term institutionalization of government expense, including funding by Medicaid. Focusing on these two, that's income maintenance and long-term institutionalization, allows DHS to focus on people who could become primarily dependent on the government for subsistence without jeopardizing other benefit programs that serve significant public interests. DHS believes this approach is consistent with the natural interpretation of the term public charge and easier to administer, in contrast to Trump's 2019 rules. Now, let's jump into what is public cash assistance for income maintenance. DHS recommended the following in defining public cash assistance for income maintenance. First, supplemental security income. It's a monthly income distribution program designed to guarantee that elderly, blind, or handicapped people with minimal income and resources have a basic income level. Second is cash assistance for income maintenance under the Temporary Assistance for Needy Family. It's a TANF program. It provides cash assistance to needy families with children when the responsible individuals, such as parents, can't meet the family's basic necessities. And third, state, tribal, territorial, or local cash benefit programs for income maintenance, generally called as general assistance, but it varies state by state. These programs assist those who do not qualify for unemployment insurance or whose programs are inadequate or exhausted. Such programs can provide cash, in-kind services, groceries, and even rent. Not all cash assistance is considered for public charge purposes. If it does not constitute primary dependence, it's not going to be considered. And we're going to discuss that later on in the video. Also, earned cash benefits like Social Security benefits, pension benefits, veteran benefits, or even unemployment benefits are not considered. Now, what is long-term institutionalization at government expense? DHS proposes to replace institutional for long-term care of government expense with long-term institutionalization of government expense. Doesn't sound much different, does it? They're talking about admission to a nursing home or a mental health facility. If you rely on the government's aid, you're going to be a public charge. Remember, this is the only type of Medicaid funded service that is taken into account in public charge inadmissibility determinations. This means that Medicaid funded home and community based services are not counted. In addition, DHS excludes from the definition those who are in prison, because obviously you're institutionalized at the government expense. So in prison because of a criminal conviction or short periods of institutionalization for rehabilitation purposes are not considered. Rule number 3, exclusion of non-cash benefits from public charge determination. The primary goal of non-cash benefits is to provide supplemental help to low-income families. DHS proposes that these non-cash benefits are not part of the public charge inadmissibility determination. Unlike Trump's 2019 rule, the following non-cash benefits are not considered in public charge determination. Food stamps. Again, you get a credit, you get a voucher, but you don't get cash. Children's Health Insurance Program, CHIP, and their related state programs. Women, infant, and children food and nutrition services, known as WIC. Medicaid, with the exception of long-term institutionalization of government expense, Medicaid not included. Housing benefits, transportation vouchers. Big deal. Proposed rule number 4, defining the term receipt of public benefits. So what does it mean to receive public benefit? Well, it should be defined separately than likely at any time to become a public charge. In other words, just because you receive a public benefit doesn't mean you are likely to become a public charge. Receipt of public benefits when a non-citizen is listed as a beneficiary of a public benefit. The following acts don't meet the definition. The act of applying for a public benefit, irrespective if it's for the non-citizen or somewhere else, just applying does not mean you receive public benefits. Approval to receive a public benefit in the future, irrespective if it's for a non-citizen or someone else. Receipt means you have received it in the past, not you will receive it in the future. Non-citizen who gets public benefits entirely on behalf of another individual. For example, immigrants' parents getting a benefit on behalf of their U.S. citizen child. That is the most common example. That is not receipt of public benefits for the non-citizen. And remember, it's the non-citizen who wants to get the green card. Proposed rule number 5, public charge inadmissibility determinations. In the 2019 final rule, some statutory minimum factors were weighted as negative or positive. DHS now deems that ineffective since it results in way too much information collected and then it has to be evaluated by the agency. Public charge inadmissibility decisions should only consider minimum statutory factors like age, health, family circumstances, assets, resources, financial status, education, or skills, or the like. A sufficient affidavit support, referred to as Form I-864, and whether the alien currently is receiving public benefits or has received them in the past, or both. The officer has to weigh the totality of the applicant's circumstances. You can't just focus on one factor in deciding whether the applicant can become a public charge. For example, being disabled alone is not sufficient basis to determine whether an applicant may become a public charge. What happens if you won the lottery? What happens if you're disabled as a result of workers' comp, an accident at work or an accident and you find someone else responsible and you get a large settlement? So you may have assets. You're not automatically a public charge just because you're disabled. DHS hopes that by making these changes, the public charge will become easier for individuals to understand and apply, and for the agency to review and evaluate. And on the whole, I think they're right. It becomes more objective rather than subjective. One of the major problems with the Trump rules was they really weren't rules. They were kind of guidelines, and the officer could almost do whatever they want. There were so many factors. There was so much information that was requested. An officer can really focus on almost anything to decide someone might become a public charge in the future. By focusing on key terms and by defining things clearly and narrowly, I think DHS is making a much more workable rule. And that's all for today's video. If you're unsure whether your circumstances result in an inadmissibility for a public charge, schedule a consultation now at andresmecherlaw.com, and we'll be happy to figure out whether we can help you or not, or what your situation is. If you like this video and you think it's informative, please like and share it with friends and family. And if you have any ideas for future videos or comments on this one, please put your comments below. Until next time, stay healthy and be safe.